Class, shut up. All right, anyway, so back to it. This is navigating shark-infested waters, and we have such weighty IQs on that dais that the platform is in imminent danger of collapse. We've got...
Don't worry, we have it 3D scanned.
From your right to your left, Pete Speaker, managing partner of Thomas and Hafer. Smartest guy I know, and the biggest smart aleck. Kevin McNamara, partner from our Harrisburg office. Jeanette Ho, partner from our Pittsburgh office. A Carnegie Mellon University graduate. That's a pretty big deal in my life. Gordon Einhorn from the Pittsburgh office, who used to read the news on TV. I get Pittsburgh. He's actually next to me, and he's really loud. That was just wishful thinking that he'd moved to Pittsburgh. He's in the Harrisburg office and just won a big trial yesterday in Montgomery County. Thank you. And Lou Long from our Pittsburgh office, for real. Mr. Appeal is what they call him in the Superior Court. And they're going to talk about how, like, every day the bad guys and girls try to set us up, right? Oh, you want this?
Oh, yeah.
You want everything, don't you?
Well, no, if everybody can hear me, I'm just as good without the microphone. So I don't know if that's going to screw up the videotape. It will. Okay, so our point of reference here for a lot of our discussion today is going to be a case that's familiar to lots of folks in the room, the Kverner versus Commercial Union case, which was a pretty landmark decision by the Pennsylvania Supreme Court. And Gordon is going to kick off the discussion and give us some background about the Kverner case, and then lead into processing the claim as soon as you get notice of the loss.
Thank you, Lou. Can everybody hear me okay? Great. I assume that most of you are generally familiar with the Kverner case, Kverner versus Commercial Union Insurance, dating from 2006. The Kverner case became important really because of not only itself, but the many cases that arose out of it, the progeny of the Kverner case, in which there was a lot of ebb and flow with the case law and what was covered and what wasn't covered. But the general issue is the issue of faulty workmanship. You have an insured who is a contractor, and when, if there is faulty workmanship, if the product itself is damaged, is there coverage for that? The Kverner case analyzed it not in terms of the your work or your product exclusion, but in terms of whether or not it's an occurrence. And I think we have up there the general, I can't see it, but I think we have the general definition of coverage with regard to that there must be an occurrence. And the court in Kverner held that if a contractor builds something and there's something wrong with the product itself, that's not an occurrence because it's not an accident. It's an example of faulty workmanship. And so there's therefore no coverage for that. Now later on, a couple of years later, there was the famous Gambone case, Miller's Capital Insurance v. Gambone, in which it was extended. We had a contract, in that case there was a contractor built a house, there were stucco issues, there was leakage, and the court in that case held that not only was there no coverage of the faulty workmanship, but there was no damage to the other property that was damaged as well. But again, that was somewhat limited because the other property that was damaged, other than the stucco itself, was also the work of the contractor. The contractor built the entire house. So the stucco was messed up and it leaked and it did damage to the framing in other areas. Well, that was also part of the contractor's, the insured's work. And so there was no coverage for that as well. Then that got extended even further in the Abbott furnace case. In that case, the Abbott had built, pardon me, a furnace that was defective, and it damaged the product inside the furnace. The court held that there was no damage to the furnace because that was the product of the insured. It was faulty workmanship, but extended the case law by saying there's no damage to other property, including property that was not the work of the insured. And so it had extended it even further, extended Gambone. There were additional cases which did the same thing, CPB International, Specialty Surfaces, which is a case in where they put down, the insured laid artificial turf on a football field. It leaked, and there was damage to the soil, to the lining underneath. And even though that lining was not the work, the product of the insured, there was no coverage for that either, because under the earlier cases, damage to other property, even property that was not worked on by the insured, would not be covered. The whole line of cases is rather unusual. Under most jurisdictions other than Pennsylvania, there would be coverage. There would be rather no coverage for the work of the insured, but there would be coverage for damage to other property, damage as the result of the faulty workmanship. A couple of years ago, in 2013, there was a case called Indelex, in which it looked like maybe Pennsylvania was coming more in line with other states. In that case, there was the insured's product was a manufactured window and door system which leaked. And the court said, oh, it leaked and it damaged other property that had not been constructed by the insured. And the court said there was coverage for that. So it looked like it was a change in the case law. But then later cases clarified that. They said, no, the difference there was it was a manufactured product. The insured's product was a manufactured product, pre-manufactured doors and windows that leaked. And the court said that, no, that's more of a products liability case. And also there was an active malfunction of the product. And so the court said it's different from all the earlier cases, that there would be coverage for the damage that occurred to the other property. And that's pretty much where we are now. The general lay of the land is if there is no coverage under your typical general liability policy for the actual product, the work of the insured, I'm sorry, there is no coverage for that, but there would there's no coverage for that. I'm confusing myself, I'm sorry. There's no coverage for the actual work done by the insured, and there is also no coverage for other property that is damaged unless it can be classified as an Indelex, that it was a manufactured product and it's more of a products liability type of case than a construction case. So that's the general lay of the land on Coverner.
Now, Gordon, put your claim representative hat on for a minute, and you get notice of an accident involving a construction type workmanship type problem. So this has come across your desk. What should you be thinking about initially in terms of your initial claims handling process for that type of situation?
Well, I mean, the first things you want to do, as in any claim that comes in, is to look, if there's a complaint on file, to look carefully at the allegations of the complaint. And if it's simply a matter of the damage was done to the work of the insured, if it's a case of faulty workmanship, that's fairly simple. But if you get into an area where the faulty workmanship resulted in damage to other property, because of the ebb and flow of the case law, you may want to seriously consider assigning it to outside counsel to give you an opinion on whether or not there is coverage for the damage to the other property. And you may want to, and if there are serious coverage issues, you may want to consider splitting the file so that you have one claims handler handling the defense end of it and a separate claims handler working on the coverage end. In preparation for today, I did look at case law in this area as to whether or not is it really required that you split the claim. And in Pennsylvania, there is no legal requirement that it be split, and in fact in other states as well. No court has said that you must split the claims file. But a number of courts have said that failing to split the file can be evidence of improper claims handling and can be evidence of bad faith. So not only might you want to consider sending it to outside counsel for a coverage opinion, but if it looks like there's going to be a serious coverage issue, and certainly if you think a DEC action may be filed, you really want to consider splitting the file between coverage and defense. And beyond that, you want to make sure that it's not just a formalized procedure where you do that and then don't worry about it. The commentators in this issue have made fairly clear that you got to be careful with communication between the claims handler who's doing the defense and the one that is doing the coverage issue.
The old Chinese wall.
Right, exactly. There really should be a Chinese wall between the two, at least until you get into settlement discussions late in the case, during the investigation, during the litigation. They really should not be talking to each other until you get to evaluation of the case when settlement is really on the table.
Now, one of the fallacies of the Chinese wall idea is that in most insurance companies, they're hierarchical organizations. So your field adjusters report to supervisors, and supervisors report to managers, and managers report to, I'm dating myself, branch managers. Remember when we used to have branch offices? But now they report to VPs of claims and so on. Sooner or later, those two lines of reporting are going to converge. It's inescapable. In a small company, a very small mutual, they may converge at the desk of the president of the company, but somewhere in the hierarchy they will converge. And as Gordon pointed out, the important point about the convergence and managing the convergence is dealing with the settlement process. But before we get to settlement, Pete's going to talk to us about properly documenting your claims file and some helpful do's and don'ts about things that you can say or things you want to say but don't dare ever write down in your claims file.
Well, I'll be, can you hear me? I'll be thankfully brief and general, and hopefully this will segue into what Kevin's going to cover on some specific examples. But I think, when it comes to bad faith, it's important to keep in mind that these coverage issues, in particular, and first-party claims are the most fertile ground for bad faith. Interestingly, we know, because we handle claims, that we generally don't act in bad faith. And that's not what we're trying to do. No one wants to get in trouble. The truth is we're just trying to do the right thing. But sometimes we get into trouble by not being careful in how we go about that, and in particularly how we talk about it and write about it. The best defense, of course, is good faith, and if we keep in mind that what we're trying to do in these claims is just the right thing, to be fair to the insured and do the right thing, and we're careful in the language we use when we document what we're doing and why we're doing it, that'll go a long way to keeping us out of trouble. It's easy, sometimes we deal with very difficult people, and it's easy to fall into a trap that can get you in trouble down the line if a case doesn't go well. And so we have to discipline ourselves that no matter how frustrated we are, we always have to be careful not to disparage the opposition, or not really the opposition, the insured or the insured's attorney, and to be respectful at all times. So resist that temptation to react to unkindness with unkindness. It's real easy to fall into the trap of things that kind of seem innocent. You know, we do a lot of us have a background in defending third-party claims, where the people on the other side really are our adversaries, and our job is to defend our insured. And we can talk about winning and losing and beating them and getting advantage and all that kind of terminology, all of which is completely inappropriate when you're dealing with coverage or any kind of first-party claim. Because if it goes bad, you're going to have to explain what you meant. And so we don't talk about, I'm just going to give you some examples, and I think you'll get the idea. But it's really difficult to not to fall into that winning and losing adversarial terminology. In coverage cases, we don't talk about winning. Because someday you may find yourself on the stand and they'll say, well, you wanted to win the case. What does that mean? You wanted to deny your insured the coverage they were entitled to. Is that what you meant? So we don't talk about winning. We talk about getting a fair result. We don't even talk about favorable venues. Favorable to who? You're trying to get an advantage over your insured? Instead, we talk about skilled judges, smart judges, judges who apply the law. We don't describe our insured or their counsel as a liar, for example. However, you know, you do have to document your thinking, and you have to do appropriate reporting. And so you might explain that based on these factors and circumstances which you will describe, that a fact finder might reasonably question the accuracy of this person's testimony. It really is a different style of communication, but an important one. So I could go on and on about examples, and you've all heard colorful examples of things that got people in trouble. I'm not going to do that. I think you get the idea. Be careful about your language. Always keeping in mind that this is your insured, and you are trying to be fair, and you're trying to get it right. Some other tips, I think, are obvious ones. Avoid delay. Delay just gets you in trouble. I think some of the case law that's in the materials indicates occasions where companies forfeited very important coverage rights just by delaying a matter of months in raising them. Another tip that I think Kevin will demonstrate here in some detail is we can't let any accusations go unanswered. You kind of have a feel for cases that may be trouble, and once you get that feeling, you should be considering every letter and email you get and every one you send as a likely exhibit someday blown up on the display screen in front of a jury. So I think a rule I follow is, and I recommend, is let no accusation go unanswered. And this can be a real tough job. We've all dealt with the plaintiff lawyer who writes you 2 letters a day, saying the same thing that has been said 5 times before. What I don't want to be is in a courtroom with the other side throwing up exhibits that I've got no response to. And so I let no accusation go unanswered. Sometimes your answer may just be, dear friend, I got your letters, your 2 letters of yesterday's date and your 3 letters today, and as I told you in my previous 5 letters dated various dates, copies attached here too? The answer is no. But let's have some response so that you're not sitting in the courtroom being challenged why you didn't even respond when these concerns were raised about your insured. So write them like exhibits. Those are kind of my general tips, and I think this hypothetical Kevin's going to talk about may demonstrate some of them.
All right, thank you, Pete. My topic is the bad faith setup. When I started practicing 20-some years ago, everybody in third-party context considered 1530 policies to be low limits. And then somewhere along the line, it inched up to 35, then it inched to 50, and now there's a lot of people that would tell you 100 is low limits. And when we're talking about low limits in this context, we're talking about leverage plays. And that's what the bad faith setup is all about. Essentially, for those who might not be familiar with that terminology, this is the letter that you get very early on in a claim, sometimes before it's in litigation, and the letter says, we have a clear right to your insured's policy limits. The accident was their fault. My client was grievously injured. I enclose a couple of odds and ends of substantiation, and you have 30 days to pay me. And if you don't pay me in 30 days, then I'm going to withdraw that, and I will never accept your policy limits again. I'll proceed to litigate. I will get an excess verdict. Then I'll get an assignment, and then this will be bad faith, and your exposure will be far in excess of your limited coverage. So that's what a bad faith setup letter sounds like and looks like. Those of you who have seen them know that it raises your blood pressure because typically there's something wrong there that makes it a bad faith setup. Now, the difference between bad faith setup and bad faith waiting to happen, there is a difference there, because if you get the claim in and the letter says, my client is a 45-year-old physician who is making $500,000 a year. He died a horrible death after 8 days of conscious pain and suffering. You have $100,000 in limit. The tortfeasor had 15. If you don't rapidly assess that situation for exposure, that's a bad faith claim waiting to happen. A bad faith setup claim is very different than that. A bad faith setup claim is one of those where there are some pieces missing, or it really doesn't look on its face like a case that has a limits exposure. And so in those cases, what can happen is you turn into a little bit of a playing a cat and mouse game with the other side. So as Pete said, in these situations, I really have three simple rules that apply to what you do in these situations. And step one is a strong early claim evaluation. When you have a new claim, and particularly one that presents itself with a bad faith setup situation, you want to make sure that you get a grip really fast on liability issues and on damages issues that you can glean from the available materials. There are field investigators. There are lots of sources that you can draw on to get this information. And many plaintiffs' lawyers are very, they're interested in getting you the data that you need. So what you need is a strong early grip on the claim. Is this one that looks like soft tissue, no big deal, or is this going to be one of those cases where there's a serious problem? Step two is I'm really going to just expand on what Pete said, and that I call it tennis match rules in correspondence. If someone has sent you a letter and the letter is requesting something, some information, some action on your part, the longer that letter stays in your court, the worse that it can get. So when there is something in your inbox, if you have a piece of incoming correspondence that's requesting some reaction, some response, some information, you need to hit it back. Now, sometimes hitting it back may be, I don't have what I need, or I'm waiting on a third party to get me something, or but you can still hit it back and put the ball in the other side's court. And so every time someone hits the ball to you by sending email or other correspondence, you need to make some response, and the best response is a substantive response. Step 3 in this process is precision in responses. If you get a piece of correspondence that has 5 points to it, is medical bills, medical records, liability for the accident, future loss of earning capacity, you've got to be prepared to go point by point. If you send correspondence responsive to a 5-point letter that has 1 or 2 or 3 things to it, you are running a risk of being deemed unresponsive. Because make no mistake, in this bad faith setup situation, you are both creating exhibits. And that's what this is really all about, particularly in a setup situation, because what you need to do is you need to diffuse that situation, and you need to respond and make sure that you've got all the data that you have and that the other side understands what your position is. So a few years ago, I was invited to get involved in a claim by somebody in this room who shall remain nameless, but she had a letter from a very aggressive Scranton attorney. And that lawyer sent a classic bad faith setup letter. And the letter, there were 2 claimants. They were both involved in the same low-speed impact accident. Our insured had advised claims that there was virtually no damage to either vehicle, and yet we had 2 people. One was a guy that was 50-ish, and the other one was his mother, who was 70-ish. And we didn't get really a clear picture of what this claim was all about, because plaintiff's counsel's initial setup letter came with a smattering of post-accident records that really documented that these people were getting very aggressive treatment. They were getting injections. The male claimant was being set up for surgery, and surgery was imminent. And in view of all this, counsel said, well, you need to tender your coverage. We had a 100-300 policy. There were 2 claimants, so he wanted 100 apiece, and he wanted it now. And the initial letter, which I haven't included in the materials, but the initial letter basically says you have to pay my people now. And he added one more element. There was an underinsured motorist carrier that was involved too that had already paid some money. Now the underinsured motorist carrier had modest limits, and one of these claims was settled for $5,000 out of a $50,000 policy, and the other settled for 10 or 15. So they took significantly less than the available limits. And then this game started. And the claims representative that had it basically said, well, what do we do? You know, this guy, we have a third-party claimant who is in the process of getting surgery. We have another claimant who's getting very aggressive, very invasive treatment. What do we do now? And we've got these letters, and my response was, well, what do you know? And what don't you know? And the truth was, we hardly knew anything. But we went through the post-incident records that were provided and took those things and dug out a couple of nuggets, like in the initial ER admission report on existing medications. Both of these people were taking powerful narcotic pain control medications. We had the ambulance trip sheet, which indicated that although there was an ambulance there, both people declined transport. Both told the police officer, and it was recorded in the police report, that they were uninjured. And so we had a smattering of knowledge about something that was going on before, but we had no pre-incident records. So I'm not going to go through chapter and verse, but because we don't have time to do it here today, but I have enclosed a copy of the back and forth correspondence that starts at page 42 with claims first response letter to the bad faith setup. And what we did was every time a fax, an email, and this lawyer tried all of that. He tried, and what he was hoping was that somebody wouldn't answer one of these letters or one of these emails or one of these faxes. He started out with letters that he would mail that we would get 8, 9, 10 days after they were mailed. which would lead you to question whether they were mailed on the day that they say, because it doesn't take that long for correspondence to travel from here to there. So we would start out the letters with things like, well, I have your letter of, such and such a date, which was received here on such and such a date. And then go point by point through the things that were being said and diffuse them all and say, listen, we need information. We need your client's pre-accident records. We need this data. And here's why. Here's why we're asking. Here's why we're not going to tender the amounts that you ask. And so we put the ball back in his court. And then the next move was he started sending faxes and hoping, I guess, that we wouldn't respond to faxes. But the claims rep promptly got the faxes to me, and then what we did was we fashioned a response to each and every one of these letters. As soon as the ball came into our court, within a day or two, we would hit it back. And then sure.
I've handled many cases in Scranton, but I've never run into this Baltimore.
Yeah. Yeah, I was trying to inject a little bit of humor in this by changing the names to Harry Potter and Voldemort. It wouldn't take many of you long to figure out who this lawyer is, or at least to come up with a short list. I'm telling you, it's a Scranton area lawyer who was very industrious. But essentially what happened was we did this back and forth, and we did it for months. And he would send us a little bit of data and then say, well, I can't get you pre-incident records, and you don't need to see them. And so we would send back a response. And it went back and forth for 6 months until finally we had enough data to make an offer on one of the claims, and then eventually enough data to make an offer on the other claim. It never turned into a bad faith case, and we ended up, I think, saving $80,000 on the total limit. So these letters were designed to give an illustration of one way of trying to deal with these things, and the way that we did in that case, and the timeliness and the thoroughness that you really need to pour into these types of cases to diffuse a bad faith setup situation. So, anybody have any questions? I'll pass the mic.
Before we jump in with Jeanette, dealing with the pen pal is probably one of the hardest bad faith setups to respond to. And with technology comes increased demands, because now we all have email. And when I started practicing law, the turnaround time used to be about 2 weeks. Somebody'd send you a letter and you'd have about 2 weeks to respond and everybody'd be okay. Well, then along came fax machines, and now we have emails. And so you get an email at 10 o'clock, and if you haven't thought about responding to it by 1 p.m., you might get another email saying, why are you ignoring me? You haven't responded to my 10 o'clock email. And that came in at 1:15. So it really has picked up the pace. It's made things much more demanding for you. It's made things much more demanding for us. Now, Jeanette is going to talk to us about something which is also sometimes very time sensitive and needs to be very precise, and that's writing your reservations of rights. Who here has not written a reservation of rights letter? Good. Okay, everybody knows what it is. Everybody's done it. But Jeanette's going to tell us in a little bit more detail what goes into a good one and what things you're going to need to be on the lookout for.
All right, since you all are familiar with reservation of rights letters, I'll just go into some things that you should always think about when you're writing your reservation of rights letters. Can you hear me okay? First of all, make sure you have the correct version of the policy. Having the wrong version never turns out well. Also, when you're writing your reservation of rights letter, make sure that you're quoting the policy provisions correctly. Also, make sure that you have a complete copy of the policy. Quoting, using the wrong version of the policy, quoting or misquoting policy language can lead to the company being accused of violating the Unfair Insurance Practices Act by misrepresenting the provisions in the policy. So always make sure, double check, triple check that you have everything that you need, and that what's in your letter is actually what's in the policy itself. Also, set out the facts as you currently know them so that everyone is on the same page that, this is what the claim is, this is what the complaint says, et cetera. Also set out the company's position in clear and definite terms. A reservation of rights letter is no place to be wishy-washy. Don't use terms that could mean, that could be taken one way or the other. Make sure that you're being clear and definite about what the company's coverage position is. Also, don't simply quote from the policy. Explain or give some context for how the policy provisions and the facts as you currently know them interact to impact upon coverage or potential lack of coverage for a particular claim. Also, make sure that you are addressing all potentially applicable policy provisions, just to try to avoid arguments later that you somehow waived particular provisions because you didn't mention them as soon as you were aware that they might apply to a particular position or situation. Also state that while the company is providing the insured with the defense now, it's reserving its right to withdraw from the defense at a later time if such action would be deemed to be appropriate given the facts as known at that particular point in time. Also state that in the event further investigation reveals that additional policy provisions might be implicated, that the company reserves its rights to also rely on those subsequent policy provisions to either withdraw from the claim or decline to pay a judgment. Always invite the insured to review the company's coverage position with a counsel of his or her own choice, so that they're clear that they don't have to take your word for it, that they're free and should, if they so desire, seek legal advice on their own.
If I could just jump in and add a footnote for those of you who work in West Virginia. In West Virginia, all claim denial letters have to contain a provision that says that the denial can be reviewed by the insurance commissioner in West Virginia. When I started doing West Virginia coverage cases, I adapted that, so whenever I write a reservation of rights in West Virginia, even though you don't have to, I tell the insured, you can have this reservation reviewed by the West Virginia Insurance Commissioner. So very important. Even though it's not required in Pennsylvania, you might want to consider being a little more proactive and saying that it could be reviewed by the Pennsylvania Insurance Commissioner. Sorry, Jeanette.
No problem at all. Similarly, in a way of trying to make this a two-way street, always invite the insured to provide the company with any additional information that the insured might have, which they believe might impact upon the company's coverage position, that therefore putting the ball back into their court to come forward if there's additional information that they feel that the company should be considering. Also, make sure that you're sending the reservation of rights letter to all people who might possibly be entitled to coverage under the policy for the particular claim. Simply sending a reservation of rights letter to the named insured is not enough. Sending the reservation of rights letter to the named insured will not necessarily reserve the company's rights with respect to other individuals or entities that might be entitled to coverage. For instance, there is a Pennsylvania case involving a homeowner's policy where the company sent 2 separate reservation of rights letters to the named insured homeowners. However, no reservation of rights letter was ever sent to their daughter, who was also a defendant. The court held that because the daughter was an adult, the company simply sending a reservation of rights letter to the parents was not sufficient to reserve the company's rights as to her. This was the case even though the daughter was living with her parents at the time both letters were sent. So make sure that when you're drafting a reservation of rights letter that you're addressing it to all potentially impacted parties. Also make sure that you're sending the reservation of rights letter to the correct address. And also that it's being sent by a certified mail return receipt requested. That way you'll have the return receipt demonstrating that someone on the other end actually received the letter in the event that ever becomes an issue. There's also a few cases in the written materials that I provided which discuss reservation of rights letters which were deemed inadequate and therefore were insufficient to preserve the company's rights to decline or to challenge coverage for a particular claim. I won't take up our time going through them. they're there for your amusement or or edification if you want to read them. Thank you.
Pete, I understand you wanted to supplement something on the reservation of rights front.
Yeah, this is, I'm not going to talk at length about it, but this is something you may want to put at the top of your checklist, and that is whether you want to reserve your rights. And here's why I say that. There's a case that came out just 2 years ago, a 3-2 decision by the 5 justices who heard the case, called Babcock and Wilcox versus American Nuclear Insurers. Anybody familiar with that case? This is a case that hasn't had a lot of impact yet, but I predict it's going to change the way we do things, and certainly should be considered in any case. It's a big case and involves a questionable coverage issue. Again, I'm going to try not to go into too much detail, but this was a case, this is an $80 million settlement. It's a case where the ANI, the nuclear insurers, were defending these TMI cases that you may remember, cases that I think were meritless cases, allegations of radiation exposure from TMI. But they were in litigation for decades. And ANI and other insurers were defending them under a reservation of rights. They owed, I think it's pretty clear they owed most of the coverage, but there were certain potential claims that they reserved their rights on. There was an opportunity, there were settlement negotiations, and the insurance companies weren't particularly interested in big settlements because they had very good defenses. The insureds, the nuclear people, went ahead and settled the case, a number of cases, for $80 million. The insurance companies came in and said, well, we have a contract that says you can't settle cases without our consent. And thus we had the litigation. In the end, here's what the Supreme Court held, put as simply as I can. In a case where you've reserved your rights, the insured can enter into a settlement agreement. You're going to have to pay it if they prove that there was coverage. That means there were covered claims. Okay, that doesn't necessarily mean they were all covered. And that from the perspective of the insured, the settlement was reasonable. That's it. They don't have to prove that you acted in bad faith. Your contention that the claims were defensible will not excuse you. Okay, that's huge. It really hasn't seemed to had a whole lot of impact other than the $80 million in that case yet. But think about it, where you have a big case, some coverage, you probably owe them most of the coverage, let's say, and you want to retain control over the settlement decisions, you should think twice about reserving your rights.
Two questions about that.
Yeah.
Was there a deck action pending in that case, in addition to the
I believe there was, and I think it was stayed in part, perhaps. There was at one point, and I think it got stayed.
Well, the deck action doesn't protect you from that.
No.
And then second, if that case doesn't say, though, that you would have to pay above your limits.
No. If they were trying to hold you to a payment above your limits, they would have to prove bad faith as well. One of the important distinctions here is they don't have to prove bad faith. All they have to prove is that there were covered claims and that they were settled reasonably from the perspective of your insured. So, I mean, it's an 18-page, single-space, complicated decision that's going to be interpreted for the next couple of decades, but it's something that people that handle coverage issues should be very concerned about.
And lest you think that it only applies when your insured has the wherewithal to make a substantial settlement payment, don't forget that there is the vehicle of policy assignments that the insured can enter into with the claimant and assign the claimant policy rights and open up the direct claim against the insurance company.
Yeah, in that case, they happened to note that Babcock and Wilcox just happened to have $80 million sitting around that they could, use to settle. But it does not say that it won't apply to cases of assignment, and I think it will apply to cases of assignment.
Yeah, and one of the problems with assignment cases is that it puts the insured and the claimant in control of determining how much money you might have to pay. So they could overvalue the case, and the fact that they overvalued the case, let's say you've got a $500,000 policy limit, and they agree to settle for $495,000 and make the assignment. You've lost your ability to establish that the fair value of that case is something less than $495. So it's certainly something important to keep in mind. We've got a few minutes left over, and so one of the points I'm going to throw out to the panel, and any of you can jump in on it, is when to file a declaratory judgment action. How soon should you do it? When do you bring the coverage issues to the attention of the court?
I think generally in a case where you're going to defend under a reservation of rights, in general, as soon as possible. Because you don't want to get in a situation, for example, where the case is going to go, the underlying case is going to go to trial. You don't have a coverage determination. And let's say a judgment is entered against your insured, okay? And even if it's appealed, they can execute on the judgment. And then you're going to have a real dilemma what to do in terms of protecting your insured against the sheriff levying on their property while you still have a coverage dispute.
The next question then is, where do you file suit with your DEC action? You've recently had an experience with a coordination problem between maintaining cases in two different counties simultaneously.
I think I can answer that question. It would be wherever there are smart judges who apply the law.
Yeah, there was a time, just within the last few years, where usually the decision is, do I file this in state court or do I file it in federal court? And a lot of times when you're in state court, there may be good reasons not to bring an action in state court. As long as you have diversity and you have enough amount in controversy, you might want to think about bringing a declaratory case in federal court. It will typically move faster, and you do tend, not in every case, but in many cases, to get a much more thoughtful decision from a federal court judge. Now, there was a rage a couple years ago where the federal courts were refusing to look at state court declaratory actions. I had a couple that got kicked back to me that I thought, oh, I must have screwed something up in the filing, and the bottom line was that the judge just decided that day that it was a case that he was not going to hear, and then it got kicked back. More recently, I have seen this less and less. So I think federal courts can still refuse to exercise jurisdiction over a declaratory case, largely involving a question of state law and application of insurance policy. But I have seen it fewer times lately. The federal cases I've filed have been taken and decided.
Yeah, we're defending one now in federal court, and the other side included a claim for, they were arguing that they were an additional insured under our policy, and so they included a claim for attorney's fees as a breach of contract claim to try to avoid that risk of being kicked out of federal court on essentially a state law question, declaratory judgment action. Thank you.
Take 10 minutes and come right back.